join
Sir?
join
Yes, sir. But we will start at 10, sir. We will start at the correct time.
Okay.
Okay, it's 10 now. So, good morning, everyone. Today we are having a session on IPR, and the topic we are dealing today is copyright. So, we have Dr. Lawwellman, sir, Assistant Professor in Law, Government Law College, Calicut. So, I'd love to welcome sir to conduct the session. Over to you, sir.
Thank you so much, Shirin, for the introduction. I don't think we require introduction every day because all of us are very much familiar. So that formality can be done. Okay. Anyway, very good morning to everyone. I hope the people will join the course of time. I hope I am audible and the slides are also visible. Abjit?
Yes, sir.
Shirin? Is
Yes,
it
sir.
visible?
Yes,
And
sir.
I am audible.
Slides are. Yes, sir.
I'm
Audible.
so everything is set for the presentation. So today, for the next 1 hour or so, what we are going to do is to continue our discussion on copyright. Goes without saying, we were discussing copyright and intellectual property rights. And we'll be spending around 4 hours on copyright. And we have already spent 1 hour on copyright. And this is the second day. So this is a continuation. Before we move with our discussion from where we stopped, it will be in order for us to have a recap of what we discussed in the last class, because it's quite long since we met. So as far as copyright is concerned, all of us know that it is one of the major intellectual property item of intellectual property legal regime in India and elsewhere. And things we discussed in the copyright so far are available on screen. I invite your attention to the screen as well. Copyright is a system for the protection of literary and artistic works. That's a general understanding you and I have. And such creations are known as works. I've put that in bold. That's a word we will be using perhaps all through our discussion on copyright. And we also went on to understand why copyright. It says that copyright acts as an incentive for the people who create literary and artistic works. So copyright contributes to create by giving creators incentives in the form of recognition and fair economic rewards. And under the system of rights, creators are assured that their works can be disseminated without fear of unauthorized copying or piracy. The way in which copyright companies, the copyright holders, make money is by exploiting it, allowing people to view it, people to buy it, etc. And that right should be given to these people alone, so that they will have the monopoly and they will be able to recoup their investment. Not only that, they will be able to recoup some fair economic reward. Whether the economic reward they are reaping now, the company is reap now, whether it is fair or not is a matter to be discussed, and it is to be discussed critically. But we may not be doing that today. That's not our area of discussion, because we don't have so much of time to do that. And then we went on to see this particular slide. I hope you remember this. And the law is Copyright Act 1957. As it is an objective type examination which you are going to face, perhaps this one also would be handy for you. And then we went to section 13 of copyright law, wherein the subject matters of copyright are specifically mentioned. That way, section 13 has an important position in copyright law. So as per that, Section 13 lists out as many as six items as subject matters of copyright. In other words, if a creator wants to claim copyright in anything, he should prove that his subject matter comes in any of these subject matters. Let's have a look at that. We had a look at that already, but let's look at that and let's have a look at that again. So the subject matters of copyright as per Section 13 of copyright law, Indian copyright law, are: the first one is literary work, artistic work, dramatic work, musical work, sound recording, and cinema. So unless a person is able to prove that his creative work can be categorized into any of these, is not having copyright protection. That's a understanding we may have to carry home. And we went on to understand each of these. We were in that exercise. It was during that exercise that we wound up our last class. So the first one is literary work. And the usual understanding of a literary work can go well with the God of Small Things or any other literary novels or any writings of that sort. And the dictionary meaning says that literary work should have literary content. And usually people like you and me will not categorize a jurisprudence book or a book on mathematics or physics as a literary work. That is not our understanding. That is not our common sensical understanding. But the sense of copyright law does not go well with our dictionary understanding. Copyright law has a very different agenda altogether. So every law is to be interpreted. We all have learned interpretation of law. Every law should be interpreted keeping in mind the policy behind it. So the policy behind copyright law, as you might already understand, it is to give incentive to creative works and also to give back the people who invest. So any person who is putting some labor, any intellectual laborer, should be given a reward, given an incentive, so that he will create more, and that will in a way, in an indirect way, it will be the society as well. And for this creation and then dissemination that to society, we require publishers who will invest. So these are the two major agenda behind creative actions. Creativity should be incentivized, and investment should be properly given something back. Quid pro quo should be given. So keeping this in mind, courts have said even a mathematics and statistics textbook, which you can see on the screen also, just a contextual example, that is also copyrightable as a literary work. The reason behind, which we have already discussed, was this: even behind a mathematics textbook, even behind a jurisprudence textbook, there is an intellectual effort. There is an intellectual labor. And that textbook or that book is also the brainchild, comes out of the intellectual labor of a person. So there is intellectual labor, and that is a creative thing. That may not go well with our understanding, our dictionary understanding of literary work. Nevertheless, the copyright law and the copyright judges have said that it is a literary work because there is creative labor behind it. And further, even for the publication of this and dissemination of this book, be it a mathematics textbook, be it a jurisprudence textbook, there is investment behind this. So to incentivize both of these, copyright law says your understanding, my understanding of literary work under copyright law should be a bit oriented towards practical realities of industry. Because as we already know, intellectual property has a lot of investment dimensions to that, economic dimensions to that. So our understanding is this: literary work means anything in print and writing, behind which there is investment and there is intellectual labor. That's understand. And we have a list of literary work here. Just I invite your attention to the screen. So when we say literary work, it could be include books, novels, poems, textbooks. This is just a commonsensical list, but let's codify common sense. It could be letters sent by a father to daughter or anybody to one of you to another one. It also could be copyrightable. Then question papers, which you and I face, answer scripts. Some of them are I felt that some of them should be given copyright. So beautiful and wonderful and strange. And some abridgments. That is, what you do is you make a short thing of a bigger book, abridgment. That's also a copyrightable thing. Then compilations will be eligible for copyright. Then encyclopedia. Then dictionaries. Then even software. Even software is also written in some machine readable language. But first of all, you will be preparing that in a human readable language. Then that will get converted into words, zeros and ones, and things like that. So that's also a kind of writing. That's also a kind of expression behind which there is intellectual labor, behind which there is investment. Or put it in different words, in copyrightable economic terms. An industry is looking for protection, and that is afforded by copyright law. Copyright law is so adjusted so that even software industry can be brought within its fold. It also gets protection. That was a concern, that was a policy concern behind the courts and the law. So these things have already been discussed. So I think that was a nice recap. Then the question we addressed was this: as far as literary work is concerned, does literary work under copyright law require literary merit? So coming to this question, the most important question, perhaps one of the most important cases which you can't live in copyright is London University Press Limited versus University Tutorial Press Limited. In fact, half an hour back, myself and Safi sir had a chat wherein he was making a mention that we should have a case presentation sessions also in between, wherein people like me is supposed to give some 25 cases, 25 important cases in the area where which I deal with. For example, in intellectual property. So definitely, the first case I'm going to put in that list is going to be London University Press Limited versus University Tutorial Press Limited case. This is one of the most important cases in copyright law in intellectual property. So we discussed that, and the observation we had a look at was this: literary work covers work which is expressed in print or writing, irrespective of the question whether the quality or style is high. That need not be of the style or quality of Arundhati Roy or M.T. Vasudevan Nair or anyone of that sort. It could be the style and quality of what you and I write. That's enough. The only thing is that there should be intellectual labor behind it. And the court went on to observe papers set by examiners. In that case, as I had already shared with you, it was mathematics question paper, and the copyright behind that, the protection of that was questioned in London University Press Limited case, wherein the London University degree question papers were printed and published without the permission of London University by a private publisher, which they wanted to stop. But private publisher did not yield. Ultimately, they went to copyright law for resort, and they got one. And one of the major questions, or rather major contentions on the other side, was this a mathematics question paper, even in wildest of imaginations, cannot be considered as a literary work. Then the court had to pronounce its judgment in the line which I shared with you. It need not be of literary quality or literary style. Even behind mathematics question paper, there is intellectual labor. Even in printing and publishing that, there is an investment behind it. So if there is investment behind it, then if there is intellectual labor behind it, then even question papers set by examiners are, in my opinion, in the opinion of the judge in 1906, literary work within the meaning of the present act, within the meaning of copyright law. That's what the court said. So moving on with our discussion, we have a definition of literary work under copyright law. The definition goes like this, which you can see on the screen. Section 2O, but it may not be of much of help to understand what literary work is. But I thought it would be in order for us to have a look at that as well. So literary work includes, as people like you and me have an understanding of interpretation, a definition which starts with includes is not an exhaustive definition. It only says that literary work would mean many things, and in that it would include this one also. So this is not an exhaustive one. It does not say literary work means. Instead, notably, conspicuously, literary work includes programs. It says it adds to the list of commonsensical understanding computer programs. Computer program may not go well with our understanding of literary work, but the definition adds computer program to the list. It also says the tables, a tabular arrangement of anything, tabular arrangement of anything. Usually we do not consider that as a literary work, but the section says law adds to the list. Even a table can be a literary work. A compilation of data. So even in collection and arrangement of data in one place into a particular book, even that requires a lot of knowledge, a lot of intellectual labor. That also will be now eligible for compilation of data, including computer database. Even computer database, wherein a lot of mechanical help comes in, even a computer database will come within the definition of literary work. So our literary work, the understanding of literary work and the protection afforded by the copyright law as literary work is as wide as this. It includes a list we saw. We should be keeping in mind the London University Press Limited case and the policy the court put that across, and also the definition which is available to the available in the copyright. All these put together will make our understanding of literary work under copyright law. Would that be all right, Hagen?
Yes, sir. Yes, sir.
If that's fine, then let's move to the next item. So we
Sir,
have the list
sir,
of
one question.
copyrightable.
Abridgments എന്തായിരുന്നു sir?
Sorry, Hagen, would you repeat?
Sir, abridgments എന്തായിരുന്നു abridgments?
Abridgment, I had made a mention of that. Abridgment means you have a
Abridgments,
big text.
sir.
Yeah, that's what I'm saying. You have a big text. You have a novel of Shakespeare. So, but that will be a very bulky thing. What you do is, or what somebody else, or somebody else does is, the person is making a abridged version of that. He'll be making it one third of it. You must have attempted questions of abridgment in your question papers in Malayalam or in English or perhaps in Hindi also. So you have a bigger text. You will have to cull out the important ones, and you will have to make it a shorter one of 1/3 size. So you have a big book, you have read it, and you are making it available for in a simple manner, in an abridged manner for the students. You get the abridged versions of Shakespeare's novels and many other things. So abridgment means something which is reduced into size, and wherein you will have all the important matters. It will be a distilled essence of a bigger thing, wherein the heart and the brain won't be lost. Okay. I think it's clear. Thank you for that response. Now, let's get back to Section 13. Section 13 speaks about 6 categories of subject matters. We have an idea of literary work already. So we have a reasonable level of understanding. Let's move to the second. The second one is artistic work, which is available on screen now. So when it comes to artistic work, this is definitely a classic artistic work, which every one of us have come across. I need not ask what this is. Now the question here is, a principle similar to that of literary work will be applicable in the case of artistic work also. Here also, the principle could be understood like this. Anything which can be classified into artistic category, whether it is having a very high artistic quality or not. So again, artistic quality as such is not a major criterion to decide what is artistic work under copyright law. So a comparison with literary work and the understanding there can be transported to the understanding of artistic work. With that observation, let us look at some of the examples. A painting is an artistic work. All of us will agree. A sculpture, yes. A drawing, not a problem. A diagram. Do you consider a diagram as an artistic work usually? A diagram may not. It can have some artistic quality, but the major purpose of a diagram is different. It is trying to communicate something or compile some data. But a diagram is also, apart from the painting, etc., diagram is also artistic work under copyright law. A map is also a data-based thing. It is trying to communicate a thing, an educational thing, a thing for study, communication, etc. It will be appreciated, may not be for its artistic quality, but for other things. But even though this is considered as an artistic work under copyright law. A chart, similarly. A plan, an engraving, of course, that goes well with our understanding. A photograph, that's fine. And then I invite your attention to that last sentence there, wherein you have a better, a different color also. Whether or not any such work possesses artistic quality. So whether the work possesses artistic quality or not, that is not the question. Whether there is an effort behind it, is there investment behind the publication and dissemination of that to the society? If those two questions are answered in affirmative, if the answers are yes, then it is an artistic work, if it is into these categories. So I think I need not dwell much more on this because it goes well with our understanding of literary work and the principle there. If that is so, let us just have a look at a glance at the definition of artistic work under section 2C of copyright law, wherein it says like this: artistic work means a painting, sculpture, a drawing, including diagram, map, chart, or plan, an engraving or a photograph, whether or not any such work possesses artistic quality. That's important. A work of architecture, and any other work of artistic craftsmanship. So the idea, if you go through the definition meticulously, the idea you would absorb would be this: any of these categories and any other category has got some artistic craftsmanship, which means some effort behind it, then is also eligible for artistic work, eligible as artistic work under copyright law under section 2C. So I think these two things are our earlier slide, along with this slide, and also our understanding of literary work will be fine for our understanding of artistic work under copyright law. Can we move on, Mr. Kuriachan? Are you there?
Yes,
so that if I get some response, I feel that I'm not talking to machines, I'm talking to people. I hope it's fine, and we can move to the next. Again, the third item of third subject matter of copyright That is dramatic work. Yeah. Thank you, Sri Lakshmi, Gayatri, etc. Yeah, even a response in chat box is fine with me. Now let's move to dramatic work, the third item of copyright law. This is the picture visualization every one of us would have. Dramatic work is this: a drama which is enacted on the stage, and that is right as well. What are the ways in which a drama can be expressed? It can be enacted on stage. It can be written on a book. You must have read a drama, wherein the arrangement is very different. The treatment and the approach to the subject is very different. It is a scene-by-scene arrangement wherein you have dialogues, you have a context, you have a place where it is happening, you have a situation where in which it's happening. All those are there. So the major distinction between a literary work, which is also in writing, and a drama which can also be expressed in writing, is this: in the case of literary work, it's just a plain, simple writing. Not that very simple, but that's also a narration kind of thing. But here you have characters in this, and they would speak. There is a background for that. There is a particular situation in which it is happening. So a scene-by-scene arrangement, that would be the heart of dramatic work. That would be the point that will make dramatic work different from literary work. Scene-by-scene arrangement where you have dialogues as well. So that's a different, approach. That's a different expression altogether. Those who have read it would understand that. So a drama could be something like this. You will have all this, and drama can be recorded. Need not say that. Somebody can just have a audio recorder when drama is enacted, or a person can have a video recorder, just kept it as it is. That's also a drama, from where you can retrieve that drama. Drama can be written, which we have already discussed. And an important understanding we may have to add to your understanding is screenplay. Screenplay, which is related to a film, a screenplay of the film, which is a backbone of a film. I heard somebody say, one of the directors say, a screenplay is the backbone of a film. So even in a film screenplay, you have the same thing. You might have read some screenplay of some of the screenplays written by M.T. Vasudevan Nair, the legendary Jnanpith laureate. So wherein you get to see the scene-by-scene arrangement of the characters, and the entire story will be rewritten in a different form. So I got to read a Malayalam novel, Madilugal, which was written by Bashir, and it was converted as a dramatic work, a screenplay. I think Adur Gopalakrishnan, the national award winner, had done it. So if you see both, if you try to compare both, you really understand the effort behind conversion of a literary work, a story, to a screenplay or a drama. So a very different treatment. The person should have a understanding of the story, then he'll have to treat it in a very different fashion. It requires a lot of intellectual effort, and obviously there will be investment also. So my point here is, apart from the drama, understanding of drama, of recorder, written, of audio drama, you need also have to have an understanding that screenplay is also part of dramatic work under copyright law, and even film industry would rely on. The film industry would also rely on copyright in the form of dramatic work. Now, let's just have a look at the definition under Section 2H of Copyright Act 1957. And the definition goes like this: dramatic work includes, I invite your attention to the word includes, Any piece for recitation, choreographic work, or entertainment in dumb show. The scenic arrangement or acting. That could be the most important words you would note here. The scenic arrangement or acting, acting form of which is fixed in writing or otherwise. The whole thing, the whole arrangement is fixed in writing, which you and I know. It could be in the form of a book, or it could be otherwise. It could be audio, it could be video, or it could be any other digital form or otherwise. But please note, there is an exemption, but does not include a cinematograph film. A cinematograph film is not a dramatic work. So this is the arrange, and this is the understanding of dramatic work under copyright law. Would it be all right for our purpose? Advocate Jisha Jasmine. I'm just asking someone. That's all. Okay. If it is so, yeah.
It's clear, sir. Clear, sir.
Fine, fine. Thank you, thank you, thank you. Let's move to music. Let's have some music. The understanding of music under copyright law also requires some sort of amendment, modification when it comes to intellectual property. Our understanding, our commonsensical understanding will have to be amended and modified. When we say music, for Indians like you and me, it is film music, film song that that pops up in our mind, the film music. But that is not the understanding under copyright. It requires a little bit of adjustment. Under copyright law, sound recording, musical work means the sound emanating from a musical instrument, and purely that, nothing else. Here a comparison would be in order. If you compare a musical work under copyright law with a film song, in the case of film song, you have music, you have a sound emanating from musical instrument. You have somebody singing it, Sonu Nigam or Yeshudas or Vineet Srinivasan singing it, rendering it. You have somebody who have written its lyrics, which is a literary work. So it's a combination of three. You have literary works in the form of lyrics, you have rendering by someone, performance of someone, and you also have music. So it's a combination of three things. So that's a different item in copyright law, not musical work. In the case of musical work, it's pure music. Then what's this pure music? This is also a language, and this is also a writing style, which a person belonging to the musical discipline would read and understand. I don't understand this. I've not learned music. If some of you might have learned, and some of you might make sense of this. And this could be, a musical thing. And the best example I can bring to you is this. Perhaps this is the most popular thing, wherein this is something composed by the legendary A.R. Rahman, for which he took remuneration crores. It was said, I came to understand. But as far as we are concerned, the point is this: in this, there is nobody rendering anything. There is no lyrics involved. This is pure music, and pure music emanating from musical instrument. And that is what musical work for the purpose of copyright law. Now let's have a look at the definition as well. Section 2P of the Copyright Act deals with musical work. It means a work consisting of music and includes any graphical notation, which I brought you in the screen, which I couldn't make much sense. It's Greek and Latin to me. Includes any graphical notation of such work, but does not include that subtraction is also important. but does not include any words or any action intended to be sung, spoken, or performed with the music, which definitely conveys the idea that film music, wherein you have rendering by somebody, some performance by somebody, some words are spoken or sung, those won't include it. Those won't come in this. So musical work is pure music, and other one will be some other item. So this is the understanding of musical work under copyright law. With this, let's jump to the next, the fifth one in the list of subject matters under section 13 of copyright law. So sound recording. What is that?
ലിറിക്സ് എന്നുള്ളത് ഉൾപ്പെടില്ല. ലിറിക്സ് എന്നുള്ളത് മ്യൂസിക്കൽ എന്ന് പറയുമ്പോൾ ആ ഒരു സോങ് ആയാലും അതിന്റെ ലിറിക്സ്.
But what I said is that won't come in the musical work. It won't come in musical work. But we have not completed our discussion. We are just moving to the next. I think once we complete the discussion of sound recording, your question will be answered or it will subside. Please wait for a few minutes. So as far as sound recording is concerned, I've got an example here. An old example, Kishore Kumar, legendary again. A film song rendered by, I want to say something, rendered by Kishore Kumar. But here you will have music also, the sound emanating from musical instrument. You will have Javed Akhtar or somebody, a lyricist, written lines of this. So you have a combination of three things in a sound record. Kishore Kumar is singing, Yeshudas is singing, or SP Balasubramaniam might have sung that. There will be musical score from A.R. Rahman, A.R. Raja, or anybody of that sort. And there will be, lyrics from Javed Akhtar or Ramesh Nair or Kaidapuram Damodar Nambudiri or anyone of that sort. So there are three things in this. What are those? Who are those? And what are those? Singing by somebody, lyrics, and also the sound of musical instruments. So I think this answers your question, Mr. Abhijit. Does it? Abhijit?
Yes, sir.
Yes, sir.
What we consider in the ordinary parlance, the classical ordinary parlance as musical work is sound recording for the purpose of copyright law. So music industry or film industry or music industry in India relies more on, I would say, sound recording than musical work. So it seeks protection, it takes resort in the category of sound recording than musical work. Of course, musical work is also useful. Perhaps it's more sound recording is more important for them than musical work. Now, that's a composite work, we call it. And there is a definition. Section 2XX, sound recording, means a recording of sounds from which such sound may be produced, regardless of the medium on which such recording is made. It could be a tape recording. It could be a CD. It could be a DVD. It could be something, available in a site. So it is recorded there and it is kept, from which it can be reproduced. It could be retrieved again, regardless of the medium. Medium could be anything on which such recording is made, or the method by which the sounds are produced. The method in which it is being produced, will also won't matter. So any kind of sound recording, any kind of recording, and any kind of retrieval, and any kind of medium would be fine. Which means that if you have any different recording method which comes into existence in future, even that will be taken care of by definition. Now it can be what we discussed and what we understood. Shall we move on? I hope we can. Now we have the last item in the list of subject matters under section 13. It is cinematography. We have an Academy winner film and its poster there, Joker. First picture, all those, you might have come across this. Let's try to understand what it is. The question is, what are the components of a cinematographer? Let's think for ourselves. Can you just think for yourself? As we have discussed the basic materials of copyright law, it definitely will have, it's a composite work, goes without saying. It'll definitely have a story, right? A basic story will be there. And that story will be converted into screenplay, which is a dramatic work, wherein you will have dialogues as well. Now, lyrics, usually, that's a hallmark of Indian cinema, Bollywood especially. You will definitely have a couple of songs for which lyrics is a must. Music comes along. So those items are also included in this mixture of copyright. Then you have acting, wherein you have performance, you have videography, all those coming in. So this is definitely a very complicated composite copyright work, but this is given a special status, a separate status as a special category of work. But the work available, the protection available to a film will be subject to the protection or the rights, the honor of copyright. The honor of copyright in a film takes or obtains from the basic works. We should acquire rights of the story writer, screenplay writer, lyrics writer, etc., or you should employ him. That's how it happens in the industry. We may be discussing those kinds of relationships later on. So that is what a film is. If that's a requirement of a film, can't these TV serials, be it in any language, be it in Hindi or in any other language, will also be eligible to be called as cinematography film? Here also we are amending our understanding. Usually for us, it is cinema. That is what cinematography film is, which we get to see in a theater. Nowadays on Amazon Prime. But of course that is film, but we should add a few things more to the understanding of cinematography film, because they are also eligible for protection. There are people who are investing behind it. There are also people who work behind it, and there is an industry which is which is looking for some kind of legal protection. So we will be extending protection to those people as well. So serial, which will have a story, a screenplay, lyrics, music, videography, performance, etc., etc., etc. Whatever you have for a film, it is there in cinema, in a serial also. So even a serial violation, even a violation of a serial, an allegation of violation of a serial will be filed as a copyright case and a cinematograph film violation under copyright law. And in the meanwhile, I have a question, I think, from Hagen, which I will address here. So now series also may add to the list, right, sir? Yeah, that's right. That's right. Every part, every half an hour serial will be of a mega serial can be will be, if it is violated, it will be copyright violation, cinematograph film violation. Then a series also can be considered as copyright violation, and it will be violation of cinematograph film. So if that is the understanding, a comprehensive understanding of cinematograph film for the purpose of copyright law and the types of industries covered under this category are films, TV serials, documentaries. You get to see good documentaries in news channels. If you go to BBC, CNN, and etc., you get to see wonderful documentaries, very insightful and very informative. And there is a lot of a lot of information packed in it, a lot of effort, and also investment. So that it also complies with these requirements. So the violation of a documentary without the permission of the original channel can be considered as a short film which the college college students would make. That's also available, protected as cinematography film. Even a TV advertisement of few seconds, 8 seconds, will be eligible for protection as cinematography. So the people in this industry can also rely on copyright and cinematography film for the purpose of their protection. That would be our understanding. With this, we complete our discussion on different subject matters of copyright, but we won't conclude that before we have a look at the definition of film. Section 2F defines cinematograph film, and it means any work of visual recording. Audio recording is also included. Let's read the entire definition. Let's see that. A cinematograph film means any work of visual recording and includes a sound recording accompanying such a visual recording, and cinematograph shall be construed as including any work produced by any process analogous to cinematography, including video films. So if you read this definition, carefully, what we discussed in the last slide, our understanding in the last slide will be cemented. The sense it will be, our understanding will be intact, that will be justified. So it's not only just films, it includes even serials, short films, TV advertisements, documentaries, whatnot, any sort of visual recording, and the accompanying sound recording will also be considered as cinematograph film. And you can claim, that industry can claim protection of copyright law under this category. So usually when we generally speak about copyright, what we say is what we protect under copyright law is literary and artistic work. Of course, it is right, but it is literary and artistic work as we have understood now. It includes literary work as understood in the Copyright Act, copyright law, musical work as understood in the copyright law, dramatic work, then you have artistic work, you have sound recording, you have cinematograph film, and in most of these, our understanding, our common sensical understanding, will have to be amended and modified. So a greater area of coverage is available in the case of copyright, and greater area of people and industry also would have protection under copyright law. That should be our understanding. Can we move on now? Again? Or anybody?
Yes, sir.
Yes, sir. Yes, sir.
As we have understood the...
So, may I some?
Yeah, please, Randy.
Sir, this is Nidhi. Can I ask you something?
Yeah.
So we were discussing about the various copyright created protected content, right? Would you be discussing about the broadcasting, like the copyrights over live recordings and of especially sports and all, cricket and all? Or would you be please answer, why do we actually give protection for broadcasting live crickets and all? What kind of element is protected there?
Yeah. Definitely we will come to that. We will be discussing that as neighboring rights. We, as Raniel, must be knowing that. It's good that you just reminded that. It's not that I've just overlooked it. We'll definitely be discussing performers' right and also broadcasting right as a different category, but may not be along with this. So I think that will be more appropriate to discuss that. We have a few sections dealing with broadcasting organizations, their rights, and similar things. And similarly,
Okay.
we also will be discussing performers in the copyright. So we'll be discussing that at that point. Thank you for the
Okay, so
reminder.
thank you.
Definitely we will be discussing that. Now we have an understanding of the creation, the subject matter of copyright, and we need to recognize, we need to understand who is recognized as the author of the copyrightable work, who is given as recognition of the intellectual labor behind this copyrightable works. Section 2D of Copyright Act deals with that. And it could be understood like this. In the case of literary or dramatic work, the understanding of an author is an understanding we usually have, the person who is writing it. In the case of musical work, it is composer or music director. In the case of artistic work, it is the artist who is putting effort behind it. So this may not require any kind of amendment of our industry. In the case of photograph, it is the photograph. Now I want you to have a special attention to the last item in the on the screen. Film and sound recording. Both are composite works and more industry-oriented ones. Investment takes upper hand to the intellectual labor behind it. And that monetary bias, that pecuniary bias is reflected in the law also. In the case of a film, cinematograph film, the person who is given authorship is not director, is not the playwright who writes a screenplay, who is and it is not storyteller, story writer. It is a producer. What does it mean? What's a big deal the producer has in the form of intellectual labor in the production of a film? At the most, he'll be spending money for them. He'll be paying everyone, but there is no intellectual labor in that sense. So take the example of a Malayalam film, Lucifer, one of the most popular films in the recent times, wherein Mohanlal acted as the hero. Prithviraj Sukumaran, another film star, directed it. Murali Gobi came up with story and screenplay. And it is Anthony Perimbavur who is the producer. So when you consider this as an intellectual property, film as an intellectual property, and you think about the creation of that, who are contributing creatively to this production? It originates as a story, it gets converted into a screenplay, then it gets its form as the film because of the director and the directions the photographer, the videographer follows that of the director. So the most eligible person would be director, but law says no, we respect money more than intellectual labor. That monetary bias is reflective, and it could be seen like this: film and sound recording. Film and sound recording. In the case of film and sound recording, it is the producer. Kindly note, it is the producer who is considered as author of copyright law. And coming to a little more new generation thing like computer generated work. In the case of computer generated work, person who causes the work to be created, person who facilitates, person who uses the computer, the person who makes the computer work and draw a picture. And that person who is behind this, the human agent who is behind this, is given copyright authorship. That's also okay. And though I've not included it here, even the most recent phenomenon which is going to take center stage in the world is artificial intelligence. I recently attended one of the programs, summer school programs of artificial intelligence and law, and few sessions were on copyright. And one of the major issues one of the major issue was who can be given inventorship, who can be given authorship in the case of an artificial intelligence created work, for which we may have to have an understanding of artificial intelligence. Artificial intelligence is much more than computer. The point which to me the point which makes artificial intelligence distinct from computer is in the case of advanced, even artificial intelligence is of different generation. The most advanced artificial intelligence has even cognitive. Please do understand, cognitive faculty. Even cognitive faculty is learned, or if cognitive faculty is integrated in artificial intelligence. Machine learns by itself. It's not. It won't. It's hitherto this phenomenon. Usually, we need to give data that will be processed by the computer. You have an outcome. Even learning will be done by that particular machine. So the human element that is required in the case of creativity, be it inventorship, be it authorship, will be minimum. And to my knowledge, day before yesterday, an Australian court, to my understanding, for the first time in the world, an Australian court has said, not in the case of copyright, but in the case of patent, an artificial intelligence creation called invention can be given. I think there are two in that. I've not gone to the full text of it. I've read an article written by someone, a brief one, a flash one, a first impression article on that. And it says that the Australian judge did not hesitate. In fact, the Australian Patent Office was hesitant to grant inventorship for an artificial intelligence created invention. But ultimately, the judge said, yes, we will grant inventorship. Please note, it is not ownership we are talking about. Inventorship, wherein there is a direct connection between the creator and the thing created. Similar to that of an author and the thing created, the literary work. We call it as brainchild. But here, there is no human element, human agent behind this. Or even if there is human element, which we are, the need of human element will be understood when we discuss originality. So even though human element is nil or human element is minimum, which is not enough under the present law to constitute inventorship or authorship, minimum human creativity. The quantum of creativity that is necessary to constitute authorship will not be present if it is created by artificial intelligence. Nevertheless, the Australian judge is reported to have recognized or overruled the decision of the Australian Intellectual Property Office and said even an artificial intelligence created work will be eligible for inventorship, which the same idea can be transported here also. For me, I thought about this. I thought of writing an article on this. For me, artificial intelligence, in the case of artificial intelligence, there are problems. And when I attended the program, when I talked to some people, nobody hitherto joined with the idea of Australian judge. Nobody, really had an idea, had an opinion that an artificial intelligence created thing should be given authorship or inventorship. But I got to read this very recently, day before about this. I will know more about this. Perhaps it will be interesting for us to discuss that. But I'm also not fully into that. I'll have more information about this perhaps by next class, and we will discuss that. So this is the idea of author under copyright law under section 2D. And now with this, we will move to the duration of copyright. Sherin, do we have time?
Sir,
2 more minutes?
sir, may I ask it out?
Yeah, please.
Sir, by this author term, does it mean that ownership, like if the producer is given the authorship of this film and sound recording, will it mean that he is the owner of the same? So if someone take a song from the movie Lucifer, can this Anthony Perumbavoor file a case against him as a violation of copyright if they have copyrighted?
Yeah, that's a good question. I was very careful not to use the term honor when we discussed this particular slide. I was very careful not to use the term honor because usually the general principle of copyright law under section 17, which we are going to discuss after this slide, perhaps next day, it says that author is the owner of copyright. Section 17 declares so. It opens like that. But it has got very notable exceptions to it. To answer this question, we need to discuss section 17, and we'll be doing that in the next class. Author will be the first owner usually, but in certain circumstances, in certain exceptional circumstances, the authorship will be, will go to another. Authorship will be with the person who has put intellectual labor, recognized under section 2D, and ownership might go to others. We need to understand that division, that kind of what you call transportation of ownership, or the dividing of ownership and authorship, perhaps by discussing section 17, which we'll do the next class. Now, coming back to the discussion, term of copyright. How long does copyright last? Unlike any other property right, most of the intellectual property rights last for a limited period of time, limited in duration. If there is 10 cents of land available to me as property here in Wayanad, I sit in Wayanad and my ancestral home, and if I have some property here, yesterday it belonged to someone, today it might belong to me, and tomorrow it might go to someone. And that right and the property will remain till the D-Day, if it is there, which means that it is perpetual, permanent right. But that's not the case with copyright. In contradistinction to that term of an ordinary property, intellectual property has a limited duration of protection. So is the case with copyright. Chapter 5, sections 22 to 29, as I've put on the screen, and discusses those sections, discuss what is the term of copyright. And it says like this: in the case of published, literary, dramatic, musical, and artistic work, 4 basic categories. In the case of literary, dramatic, musical, and artistic work, if it is already published, the term of copyright is life of the author. Life of the author plus 60 years. Life of the author plus 60 years. And if you have already understood this, I have a question. The question is on the screen. Would you respond to this? Is this work, the cover page of which is put on the screen, is this work eligible for copyright now? Or put it in different words, if I print and publish this work, if Hagen prints and publishes this work without the permission of copyright owner, would that be a copyright violation? What do you think? We know this work, we know the author, we know the year in which the author died, and we can definitely add, we are not that very bad at maths. You can just add 60 to that. So Gandhi died in 1948, plus 60 is 2008. From 2009 onwards, there is no copyright in this. There is no copyright in this. Copyright expires. This becomes property of nobody. You can print and publish it. I can print and publish it. Anybody can print and publish it. So that is the reason you have Penguin also printing and publishing. Actually, it belonged to the Navajivan Publications of Gujarat. It was that company that was given publishing right by Mahatma Gandhi. But once it got expired, even Penguin Books is printing and publishing. There are other publishers also. That's the reason why I got this picture from Google. And there is yet another publisher publishing it, perhaps even without the original owner, because the copyright has expired, and the monopoly privilege, exclusive right, the company or the author commanded in the industry no expires. Now you can print and publish, I can print and publish, anybody can print and publish. There is perfect competition. Monopoly, in a way, it was bad, but if it is a legally protected monopoly, in the case of intellectual property, that makes a lot of difference. Till today, I was the Raja, I was the Sultan, I had the privilege, I have the exclusive right, legal monopoly of printing and publishing. I used to control the industry. From tomorrow onwards, what happens? It's perfect competition. The price comes down. And today, if you walk into a DC Books bookstall, the famous publisher in Kerala, you get a DC Books published My Experiments with Truth, because DC Books is publishing their own experiments with truth, not their own experiments, his own experiments with truth, because there is no copyright. And that makes a world of difference in an industry. So that was the rule 1 with regard to duration of copyright. When it comes to these items, which I listed, in the case of photographs, in the case of cinematograph films, in the case of sound recording, in the case of garment work, etc., etc., there is term of copyright is as per rule 2. There is no rule 2 written as a rule 2, but we can understand it for the purpose of recollection. We can understand it as rule 2, and the rule is like this. The period of copyright will be 60 years from the date of publication. So in the earlier case, in the case of published literary, dramatic, musical, and artistic, the author is connected to the life of the author plus 60 years. And the case of these items, which are listed here, it is 60 years from the date of publication. And spirit, the effect is the same. It goes to the public domain. Anybody can lay their hands on these items. There is no monopoly. There is no legal sponsored monopoly thereafter. It becomes a thing of nobody. It becomes res nullis. In that, if I use a Latin term for that, it becomes it's a thing of nobody. You can lay your hands on that. I can do that. It goes to the public domain. So I think with this we will wind up our class for the day. All right. We've taken some 5 minutes more, and my allotted time is up to 11. I think if you have anything to clarify, you can do that. Otherwise, we will wind up our class for the day. Thank you so much.
Sir, may I?
Yeah, please.
Yes. Yeah. Sir, just if sir like Gandhiji's autobiography പറഞ്ഞു. അപ്പോൾ അതുപോലെ സ്റ്റോറീസ് ലൈക്ക് ക്ലാസിക് സ്റ്റോറീസ് അങ്ങനത്തതൊക്കെ ലൈക്ക് വീണ്ടും ഓരോ പബ്ലിഷേഴ്സ് ഇറക്കുമ്പോൾ ലൈക്ക് ലാംഗ്വേജിൽ തന്നെ കുറെ ഡിഫറൻസ് വരുമല്ലോ. ലൈക്ക് ചിലത് കിഡ്സിന് വേണ്ടിയിട്ട്, കുറച്ച് എൽഡേഴ്സിന് വായിക്കാൻ, അങ്ങനത്തെ രീതിയിൽ. അപ്പൊ അതനുസരിച്ച് ചേഞ്ചസ് വരുത്തുമ്പോൾ വിൽ ദേ ഹാവ് കോപ്പിറൈറ്റ്?
See, take for example some of the Shakespearean stories, or anything of that sort. So, if a person takes a storyline from that and develops as his own, then that particular thing, because the original one will not have a copyright, because Veda Vyasan or Valmiki is no more, and the revelation in the form of Bible is not copyrightable. Anyway, it's more than 60 years now. So those things are in the public domain. So anything in the public domain can be, used by us, people like you and me. And if we are having an expression of our own, we are going to discuss that, what expression and originality, principles. So if you are converting that to an expression, if it is going through you and it takes a form, which is influenced by you, which we call as expression. And if it becomes your expression, nobody else will be able to reproduce the same form in which you express. Take for example, Vadakan Veeragatha, as written by M.T. Vasudevan. or Vaishali, which is a storyline which is taken from Mahabharata, and it is developed by M.T. Vasudevan Nair. So you can't do that. You can do and take and use the Vaishali as written by M.T. Vasudevan Nair as it is. You can't take and use Rendamoolam, the Bhiman story. Bhiman is a hero there, or the anti-hero or the failed hero there. And if M.T. Vasudevan Nair takes that from Mahabharata, for which there is no copyright, but if it goes through him and it takes its own form, in a particular expression form, and if he has blessed with originality of his own, then nobody else will be able to do that. He will have copyright. Am I making sense?
Okay. Yes, sir. Thank you, sir. Thank you.
That's my response. Thank you so much. Have a nice time. Have a nice day.
Thank you, sir.
Okay, any more doubts? Okay, I think there is no doubts. So thank you so much, sir, for an interesting and knowledgeable session. And for the rest of the students, we'll be having another session at 5 p.m. today on environmental law. That's it. Thank you. Thank you, sir. Thank you all.
Thank you so much. I would
Thank you, sir.
close the meeting. Thank you so much.